You've just been arrested for domestic violence, and in an instant, you've gone from being a parent, a partner, or a professional to being called a defendant, the accused. I know you're likely feeling a mix of shame, anger, and absolute, profound isolation. Now, you're going to hear a lot of lawyers use the cliche that a criminal case is like a game of chess. The problem is, most people love the metaphor, but when it comes to actually sitting at the board, they have no idea how to play beyond just a few basic moves. Now, take it from someone who's been playing chess since the age of 4 and practicing law for 20. Your life is not a game, and you are not a pawn. My name is William Pernik. I'm a criminal defense attorney in California and the founder of the Pernik Law Firm. And at my firm, lawyers go beyond the conventional defense, and we don't just move pieces, but we actually protect people. And today, I'm going to share with you 5 battle-tested truths to ensure that the government, the police, and the DAs do not checkmate your future. Truth number 1. Please don't try to talk your way out of a domestic violence arrest. Now, I say this with love, but please don't be an idiot. You're not going to be able to talk your way out of handcuffs. I know. The urge to explain is huge. You think that if they just heard your side, they'd realize this whole thing was blown out of proportion. It was a huge misunderstanding. They're going to apologize, shake your hand, and let you go. But you have to understand, this is not the 1960s anymore. The cops are not there to be marriage counselors. Once they have been called to a domestic violence scene in California, they have a specific mandate, and that is usually to make an arrest. The police are going to have to take someone in, and what they're trying to determine right now is who. Once the officers decide that that who is you, their only job becomes to justify that decision, which means they now need to document and gather all of the ammunition that they're going to list in their report that gets handed off to the district attorney, who is then going to use that in order to convict you. So every word you say to explain is going to get stripped out of context. It's going to potentially get twisted into something, not to help you, but to incriminate you. They could ask, hey, did you push her? And you say yes, knowing that you did so because she was slapping you. The report is going to say, defendant admitted to battery. The cops may ask, hey, did you break her phone? And you were going to say yes, because you were trying to stop her from calling the police after hitting you. You didn't want her to go to jail. And the phone that you were trying to take away fell on the ground and broke. A total accident. No crime committed. But when you get the report, what it's going to read is, defendant admitted to taking the phone and destroying the victim's property. You see, no one cares what actually happened. This is not an objective search for truth anymore. What it is a search of evidence against you. If the cops are coming out on a domestic violence call, the arrest is happening. Do not give them the evidence they are going to need to complete that arrest with a successful conviction later in court. What you need to do instead is politely ask for a lawyer and let the silence be your shield. We're going to sort it out later, professionally. Truth number 2, the reconciliation trap. This one involves your heart, and it's where good people get tripped up the most every single day. In California, you may face an emergency protective order or an EPO. That's the short-term one that the cops get on the spot. Or you could end up with a criminal protective order, a CPO, which a judge is going to issue at your first court date, the arraignment. Please be careful to not ignore these, even if the victim reaches out to you first. The moment you respond to a text, even just to say, hey, I'm sorry. Hey, tell the kids I love them. Hey, I miss you. You have walked straight into a trap that I call the reconciliation trap. Please don't fall in by sending messages through friends. Please do not use your mom or grandparents as ambassadors of goodwill. Do not show up at the house just because the kids miss you. Even if your partner told your mom that she forgives you and plans to drop everything, that does not mean squat in court. If the police get called, if the DA finds out, if this makes it back to the judge, you're going back to jail. These are not two-way restraining orders. The protected party cannot violate it. That means they can send you messages, they can come out to try and see you all they want. But if you accept that, you're going to commit a new crime. What you should do instead is follow the rules, because doing so sends a powerful message to 3 separate audiences: your prosecutor, the judge, and your partner. It's going to show the court that you are taking this seriously. It's going to show to the DA that you're not a danger. And it's going to show your partner that you're ready for a change and you're ready to do things the right way. It proves that you're serious. And if you want to maximize your chance of not getting a criminal protective order imposed that's going to kick you out of your home and separate you from your family, please watch to the rest of this video where I'm going to show you at the end how to do just that. Truth number 3, be proactive. Hard work gets great results. Now this truth number 3 is the core of our philosophy. Be proactive. Hard work gets great results, but that work has to start the moment you get released. Please do not wait until your first court date. By then, the prosecution has already set their narrative in stone, and you will have lost precious opportunity to show progress. You need to actually care about your own case, and you need to be honest not only with yourself, but also with your lawyer. That means we need to know everything that happened, the good, the bad, and the ugly. In a moment, I'm going to give you a short list of life-saving tips that can make all the difference. Number 1, please be sure to document all of your physical evidence. That means taking high-resolution photos of your injuries, marks, your ripped clothing, and doing so immediately. Bruises can fade, scratches can heal, but these photos you take, they're going to last forever. Number 2, please save the digital paper trail. Do not delete mean text or ugly voicemails. We're going to need full context to show the truth later in court if this case goes to trial. Number 3, we weren't there. We don't know who the witnesses are, but you do. Please write down the names and contact information for everyone who saw the argument or is familiar with the events or family dynamics leading up to it. We need it. I really don't care if Susie Q hates you or that Marco does not want to come to court. Let the lawyers handle the logistics. Do your job, which is to document and supply the information. Number 4, this one is super important and can make a huge difference. Please be sure to help your lawyer fill the gaps with character evidence. Tell us what we would never know about you, your partner, and your shared past or history together. Has there been infidelity or violence in your relationship? Have either of you been dishonest in the past? Is there anything else going on that the police ignored or weren't aware of? Write it down. I promise you, as lawyers, we're not here to judge. We don't care if you sound like an ass in your text messages or your angry voicemail. For us, this is a search for evidence that can help you not wear the label for the rest of your life. Defendant, felon, wife beater. You would be amazed at what a difference it can make in court if you hand it to skilled attorneys. I promise you. Truth number 4. Do not get cute with firearms if you're a gun owner and you were served with a domestic violence restraining order. Nothing pisses off a district attorney more or screams danger to a judge louder than a defendant who's playing games with firearms. In California, if you are served with a domestic violence restraining order, you must surrender your firearms, usually within 24 hours of being served. Hiding a gun today is the fastest way to make sure you will never hold one again in your future. Please don't try to get cute and clever and hide them from the law or sell them to your neighbor under the table. If you do these things, you're only going to confirm everyone's worst suspicions about you, and you're going to practically guarantee that the court will keep the no contact order in place forever, or at least for as long as legally possible. Follow the process. Turn your guns in to a licensed FFL dealer or law enforcement immediately, and be sure to document the surrender in writing and bring the paperwork to your attorney or to court. If you do things right, if you follow the rules, you may actually get all of your guns back after the case is over, or at least be allowed to legally transfer them to someone else. But if instead you get cute, you get clever, you start playing games, you not only risk losing your guns, which is a given, but also jeopardizing your entire criminal case. Truth number 5, owning the mistake and building the future. We need to be honest. Not everyone is accused wrongfully of domestic violence. Sometimes this arrest is a result of a moment where you lost control, where you did something you deeply regret, and now you're staring at the wreckage of your entire life. If that's you, I want you to really hear me. You do not have to be defined by the worst mistake you've ever made. Now, many lawyers will tell you to just keep your mouth shut and hope that she does not testify. But this is a terrible recipe for long-term success or a good family future together. It does not fix the legal problem 100% of the time, and it does not fix your relationship or you. At my firm, we try to do things differently. Instead, we use our own 3-step method where we first identify the underlying reason, whether it's a mental health issue, a substance abuse issue, or a relationship problem. Once we know what the reason was for the domestic argument, we often look for a professional or clinical solution. And then what we do is we put all of that hard work at the center of our advocacy in court. This is a very simple but highly effective approach. And what I've observed after doing this for almost 20 years is that if you do things the right way, if you work really hard, your skilled attorney can actually take that proactive growth that you've made and turn it into a diversion or a creative settlement typically on far better terms than you otherwise would have received. Now, I've promised you a bonus tip on how to avoid a criminal protective order, and here it goes. This is what you do to maximize your chances of stopping that criminal protective order at the very first hearing. And it comes down to one thing: be honest with yourself and be the first one to seek help. Please don't wait for a judge to order you into classes. By the time we get to court, it really helps if I can show the judge that you have voluntarily acknowledged the problems that led to this incident, enrolled in counseling or conflict resolution program with your spouse. It shows the court, if you're addressing your mental health needs or substance abuse problems, that you are not a threat. It shows that you are a proactive individual, solving a problem and wanting to do things the right way. That is how you win. And doing it this way does not make you guilty. It makes you smart, and it helps you achieve what you want and what your family deserves. Now, to recap, don't talk your way into a conviction. Avoid that reconciliation self-help trap. Be proactive. Don't play games with guns. Learn from your mistakes and embrace personal growth. I'm William Pernik. Thank you for watching. And please comment below if you found this video helpful. And after that, we can start working together to finally get your life back on track.